All right, well, hi everyone and welcome. Thanks for joining us today for options for students in the rapidly changing U.S. immigration landscape. We are very happy to have two immigration attorneys here to talk to you today, Kiki Mosley and Ilka, sorry if I'm butchering your name, Cesari, maybe I got that right, don't know.
That's correct, thank you.
Okay, thank you. So thanks to everyone as well who submitted questions prior to the presentation. I did submit those and get those over to them. And if you do have additional questions you want to ask throughout the course of the presentation, you can feel free to put those in the chat box. Please just keep in mind that questions do need to be more general in nature and shouldn't be case specific. So without further ado, I'm going to go ahead and turn it over to Kiki and Ilka.
Hello, everybody. Thanks for joining us. Ilka and I are very happy to be here for another year doing this panel. My name is Kiki Mosley. I am an immigration attorney. I focus mainly on family immigration issues, and also I do a lot of asylum, refugee work, and other humanitarian forms of immigration. Ilka Cesari is also joining us. She is transitioning to her home office. And Ilka is a principal at Davidson and Cesari, and they have a more wider ranging case types that they cover in their practice. And so she is going to be speaking to some of the employment-based options, and really what we're going to be focusing on this year a lot is that there are major changes, and there are proposed major changes that affect F1s specifically. So I'm going to share my screen because we do have a PowerPoint, so give me 1 second so we can kind of go through this. Okie dokie. And as Teresa said, if you have any questions, you can put them in the chat. We will cover some questions that were sent to us yesterday, and thank you for sending those. I did take out some of the more case-specific ones, but we are, going to give you all of our contact information at the end of this. So if it's something that you would like to reach out about to one of us, then we would be happy to speak with you at another time. So what we're going to be talking about today are some of the proposed rule change for F1 visa regulations, which are quite extensive. New rules that are impacting specialty occupation or H-1B employment-based visas. The new test for public charge determination that impacts non-immigrant visas, so B visas, tourist visas, and also immigrant visas, so what we would call like green card visas, and also family-based immigration benefits. And then we'll go through some of the questions. So I think probably what the best thing to do is switch up the order a little bit, and we're actually going to start with public charge so that Ilka can get settled in her home office. So there's a new test for public charge determination, and it impacts both non-immigrant and immigrant visas. So non-immigrant visas, like an F1 visa, is you do not have the intent at the time of entry to become a permanent resident, to reside here permanently in the United States. And then an immigrant visa, also more kind of colloquially known as a green card visa, is a visa based on a petition from a family member that is upon entry or admission to the United States, you are a lawful permanent resident. Your green card comes in the mail. It also affects applications for adjustment of status. So adjustment of status means that you're in a non-immigrant class you have a non-immigrant class of visa, and you are able to apply for permanent residence while remaining in the United States and get your green card without the requirement to leave and process through your home embassy or another embassy abroad. And something that is new, because the idea of public charge and a charge of inadmissibility, which means, is this something that can prevent you from being approved to get a green card or a visa? That whole concept is not new. These are updated rules that are being enforced much more aggressively. And it's now also being applied to extensions for and changes of status, say for a tourist visa or other, I mean, there are many other types of non-immigrant visas. A tourist visa would probably be the most common one. So the idea behind the public charge rule of inadmissibility is that the United States government seeks to be more aggressive and have stricter requirements for the financial considerations and abilities of both the petitioner, so the person who has acted, say, in a marriage-based case, a United States citizen spouse who has petitioned for their non-citizen spouse to get a green card or to get an immigrant visa. Those rules have become much more strict, so the bar is much higher. What used to, the old process was that there was something called an affidavit of support, which is that last bullet point on this slide, and that was all based on the petitioner's income. You had to show a minimum amount of income on your income taxes, that they had been filing income taxes for at least the last 3 years, and that number was 125% above the poverty level for the United States, which is like a published number, you know, that we all have access to, for depending upon their household size. And there are restrictions on who can use public benefits, so things like disability and SNAP benefits, et cetera. And most non-immigrants, people who aren't lawful permanent residents, and it's also restricted for them, and who are non-citizens, don't have access or the ability to apply for a lot of those benefits. But other household members do. And so the new public charge rule is extensive, and it takes a broad picture of the entire household's financial health, essentially, and it makes it much more difficult to be approved for a green card or an immigration or non-immigrant benefit when you have to meet much higher requirements. So it's a point system, and the rule went into effect nationwide on February 24th, 2020. So this is a new rule. And some of the kind of disadvantage in speaking about this rule now is that because COVID-19 shut everything down worldwide, whether it be the embassies, you know, Department of State, or the local offices within the United States, this rule came into effect, and then we don't have a lot of cases and a lot of traction on cases to be able to know ultimately how different offices or jurisdictions within the United States, how they're viewing and how they're adjudicating or making decisions based on this public charge rule. So the public charge rule looks at use of certain public benefits. So like I said, Social Security, disability, general relief assistance, whether it be state or federal. There's use of Medicaid, and there is an exemption for short-term emergency medical care, institutionalized long-term care, SNAP benefits, which are food benefits for the, you know, children, public housing, Section 8 housing, etc. Age is taken into consideration as it affects the ability to work. So an older immigrant is going to, you know, and this points calculation is going to receive less points because they are viewed as having a shorter period of time in which they will be in the workforce. Having health or medical insurance is a big plus, and diagnosis with medical conditions that are going to require extensive or long-term treatment are a minus. As far as health and medical insurance are concerned, it is not an absolute requirement that one have it, but you know, an applicant have medical insurance or access to it, but they are, USCIS and the Department of State are questioning this, and is there a real ability to obtain health insurance, which is a huge issue for so many Americans, regardless of where they were born. So that can be very difficult depending upon you know, a family's employment situation and access to, say, employer-provided medical care. Family status, which means the size of the family relative to the household income. You know, if you've got a household income of $200,000 that's quite a bit of money. But if that is taking care of 12 people, you know, it's looked to in regards to what the overall household size is, assets, resources, and financial status. So this is something that is very that is difficult for a lot of people, and because you can have assets, but many Americans carry a significant amount of debt. Academic debt and medical debt are huge sources of debt, and so they're weighed against one another on a balancing scale. So they're looking at the assets in the household, and that's compared against the debts, or weighed against the debts that somebody holds, whether you filed bankruptcy previously. And they're also looking at whether someone has applied for a fee waiver. So, you know, for many processes, the vast majority of processes in immigration, there are filing fees, and a lot of times they're quite high. For example, a green card application on its own has a $1,225 filing fee. So if you don't make a lot of money, historically, you could apply for a fee waiver and show that, you know, maybe you had a sudden household issue in which, you know, you were suffering from a financial hardship, let's say. USCIS, or the Department of Homeland Security, is now looking and seeing, have you ever applied for a fee waiver? Kind of with the thinking that if you applied for fee waivers, then, you know, now petitioning for and stating that you can support another immigrant or non-immigrant, you know, they're doubting that. Education and skills, they're looking at adequate education and skills and sufficient income, looking to education. So what is your level of education? It doesn't have to be that you have a master's, you know, if you're highly skilled in a trade, etc., but they are requiring documentation of all that. You know, transcripts, they want to see if you matriculated through a full program, you know, are you working in that field? And English proficiency, pardon me. That is new. You know, language knowledge of English really comes into play when people are applying, usually for naturalization, so to become a U.S. citizen. So now we are seeing English proficiency as a factor at multiple levels. Of course, your English proficiency is not going to be as significantly weighted if you're applying for, you know, a tourist visa versus if you are applying, say, for a green card or an immigrant visa. And then there's that affidavit of support, which I spoke to a bit before, and that's looking to the petitioner's income and really the petitioner's overall financial health. From the side of attorneys, I mean, obviously this affects applicants. From the attorney side of it, or the preparer of these applications, the amount of documentation that is required to have these successfully submitted and receipted by immigration is large, to say the least. These are, you know, these can be several hundred-page filings just on this new public charge rule in and of itself, and they're extremely invasive. You know, having all of your bank statements, you know, trying to account for like every single asset, what every single debt is, etc., is a significant work burden. And it kind of, you know, it adds additional stress to the process. So the more well prepared that one can be, and really kind of looking to, if you anticipate that you're going to have the opportunity to adjust your status, or, you know, to eventually receive an immigrant visa to become a lawful permanent resident, you know, looking to really try to keep debt down. You know, credit card debt is a big one as well. Will help, you know, looking to the future. Ilka, are you ready to head back? Okay, so now we're going to go kind of back to F1 and proposed changes.
So, hi everyone. First of all, thank you for accommodating my schedule mess up here, and thank you for having both of us here this evening. It's a pleasure to be back. Although we're here remotely, at least we're, you know, all here and connecting, and thank you for giving us the opportunity to answer your questions this evening. So as you noticed from the agenda that Kiki shared, we're covering a select few issues that we think impact you most directly. As you may imagine, over the last year, last 4 years rather, and specifically in the last year, the immigration system has significantly been attacked or changed. And so there are many other things which we're not covering, which you might have questions about at the end of this talk, and we're happy to answer those questions. And then, as Kiki mentioned, even after the fact, if you have specific questions, feel free to reach out to us. Our contact information has been shared, and we'll do our best to answer those questions in the coming weeks. So to start us off, we'll talk about the specific changes to F1. And before we get to this, I'd like to go over a little bit the history of kind of how F1s have worked traditionally and what you're used to seeing. The majority of you, I assume, are international students. So as international students, what you are used to seeing as the way that F1 status in the United States works, what changes were made previously by this administration, as well as the changes that are now being proposed and in the works. So as you know from your own practice currently, the way that F1 works is that you initially interview for a visa or you file for a change of status based on the I-20 issued to you by the school where you've been accepted. You're enrolled in a program, and then you can fairly easily, once in the United States, kind of change programs and go between different education levels. Also, in order to allow for this ease of movement between different institutions, traditionally, the way that the Immigration Service has considered F1 status, it's that it's a sort of status where you are admitted for what's called duration of status. So you are allowed to remain in the United States as long as you are, number one, complying with the terms of your study and are enrolled in school full time. But beyond that, you do not start to be considered to be unlawfully present, which is a concept that has existed in immigration since about 97. So you're not considered to be unlawfully present and have legal consequences accrue to your continuation of presence in the United States, unless and until either an immigration officer in the context of a decision on a benefit request or an immigration judge while in deportation proceedings actually makes a finding that you are someone who is a violator of your status and you are therefore accruing unlawful presence. So in August of 2018, the policy was announced before, but it became effective in August of 2018. The Immigration Service tried to move away from this policy where F1s and J1s and a handful of other students who are admitted for duration of status did not accrue unlawful presence. So what the new memo said is that F1 students are considered to begin accruing unlawful presence is either as of the effective date of the memo for those already in the United States, or from the time that they received a decision from the USCIS telling them that they no longer had a lawful right to be present in the United States. So this was identified as the point of when unlawful presence started attaching. And then they said, going forward, anyone who overstays the period of time granted on the I-20 will automatically have unlawful presence. The policy was challenged in the courts and enjoined in May of 2019. And then there was a lawsuit, Guilford College v. Wolf, which was actually decided on February 6th of 2020. And essentially the Fourth Circuit Court that heard the case permanently enjoined the new 2018 memo from being applied because they said it wasn't properly issued pursuant to the necessary steps, given that it wasn't just an interpretation of an existing rule, but it was a departure from an existing rule. So in response, now through notice and comment, the DHS announced on September 24th of 2020 that they will be changing the way that F1s work, and that this proposed rule is open for the public to comment on it and on its feasibility and the benefits versus the downsides of it by October 26th of 2020. So even though we know we have a short list of the changes, they are pretty significant changes. So currently, if you need to extend the amount of time that it will take you to finish a particular degree program, you're able to do that. Under these new regulations, you would have to finish your study within 4 years. And in addition to that, nationals of certain countries are limited to being in the United States on any particular course of study for only 2 years. Anything beyond that, instead of being able to extend your status through an I-20 extensions or an issuance of an I-20 by a new institution at a higher degree level, you would actually be required to proactively apply for an extension of status by using a form I-539. And this is where those public charge regulations would come into play that Kiki just discussed, because you would have to show that you're not likely to become a public charge on the US government in the context of that request. Plus, it gives the Immigration Service a brand new chance to look at whether or not you're someone who has immigrant intent. So each time that you're applying for an extension of a non-immigrant visa, you have to show that the nature of your presence in the United States is temporary and that you intend to return to your country of origin to pursue employment or further education, and that you intend to use your US education to benefit your future outside of the United States. You also have to show that you're maintaining a home that in your country abroad. So in that sense, having to constantly prove this up to the Immigration Service makes it a lot less likely that you will continue to receive F1 visa extensions, because at some point, if you've studied in the United States for the last 12 years, there should be a healthy dose of skepticism about your intent in returning. And even if you truly do have the intent to return, just with the passage of time and with the more ties you create to the United States, it does become more difficult to actually establish the fact that you don't have immigrant intent. So I think this makes a perfect segue to the next issue that we're covering, which is the new rules impacting H-1Bs. So just as a quick summary, H-1Bs are the most traditional way that F1 students enter the US workplace following the completion of their education. And H-1B visas are visas meant to be used by professionals who are engaged in what's called a specialty occupation. And generally, specialty occupation is an occupation for which a specific degree, 4-year degree, is required. The degree must be related to that particular field in which you intend to be employed. And you have to show that you meet the minimum criteria for that position based on your education and experience, or a combination thereof. If the employer is ever stepping outside of their regular minimum criteria for the position or the minimum criteria for the industry, then they must demonstrate a business need for such departure. Traditionally, H-1Bs are valid for a 6-year period, and there you receive an initial term of H-1B for 3 years, followed by a renewal of that term for another 3 years. H-1Bs are also subject to a cap, and there's a 65,000 total H-1B visas that are issued for individuals with bachelor's degrees, with 5,000 of those being specifically designated by treaty for Chile and Singapore. And then there's an additional 20,000 visas that are issued to those individuals who have earned a US master's degree. And individuals who have earned a US master's degree are actually able to first enter the H-1B 20,000 lottery for those visas specifically reserved, plus any of the master's cap, which is what this cap is called, any of those visas which are not chosen in that 20,000 can then be re-entered once again for the 60,000 rather, that are reserved for individuals with bachelor's degrees. And annually, the category is oversubscribed. Last year, the Immigration Service instituted a new way of processing H-1Bs, which essentially runs a lottery to decide who will be accepted for further processing at the beginning of the H-1B period, before you can even file petitions. So in the 30 days or so before the filing of the petition. And then separately from that, in April, they accept applications with supporting documentation only from those individuals who are actually selected as part of this lottery cap. Now, larger employers are able to petition and do petition for more than one position, one person, let's say, for the same position. So they could apply in the lottery for 40 H-1Bs all for the same position, and then they end up using only 20 to 30 H-1Bs. So if all the visas that were initially selected are not used up because some people decide not to go forward with the process or are rejected, if an employer in fact has additional visas in this year, they were actually able to use those visas later in the year to employ new individuals. So the new rule on H-1B, also similarly to the F-1, resulted out of litigation over prior policy. But this rule is way more final than the proposed rule that was just recently announced, in that it's what it's called an interim final rule, and it's set to take effect on December 7th of 2020, unless there's litigation which results in the rule being enjoined and not going forward. There is a comment period that's open from October 8th through December 7th related to the rule. And then there's a separate period related to the form changes that will come with this rule that expires on November 9th of 2020. So the major takeaways related to this particular rule have to do with how specialty occupation is being defined. And so traditionally, specialty occupation was defined to mean a degree in what's a traditional profession, but it did not necessarily have to be that your profession was directly related to the work that you were doing. So you could have someone who, for example, is a software engineer who's doing something that's not strictly software engineering, but based on the job description and industry standard, it was still a good fit based on that industry and it would work. The new regulations will require a direct relationship. So if you are someone who is looking for work in the software engineering field, you should be a software engineer with those specific skill sets. So it's restrictive and it's really targeting heavily the IT field, not so much traditional occupations, but heavily the IT field, because you could have a variety of skills that would make you qualified for the same occupation. And also things like if you have more of a liberal arts degree, that's more general. So you could have someone, for example, who has a business administration degree, which has been problematic actually even in the past, who applies for a position, let's say in the hospitality industry. And in the past, you could make an argument that this person is an appropriate fit. With this new restrictions, it's going to be difficult. Also, another area, there's going to be significant changes, and this has to do more with consultancy companies that were essentially hiring workers to be placed at other employers. So worksite is very specifically now going to be defined to only the physical location where the actual work is being performed by the individual. So this raises lots of questions even about work from home situations and exactly how that's going to be interpreted and what you do. And I think that's why the next clarification comes into play, that they're also trying to more specifically define that when we're talking about a third-party worksite, if an employer is working from home, you're not going to list their home as a third-party worksite, but this rule is trying to actually capture those situations where you are a professional who your employer is placing on site at a contractor or somebody along those lines. There are also going to be additional restrictions with respect to how the definition of an employee-employer relationship is being defined, to try to make it more clearly connected to the traditional definition of employer-employee, and to specifically leave out situations where an employer, again, is employing a consultant or someone of that nature, placing them at the work site of another employer, and then there's some sort of money exchange and payroll happening that is not clear on its face that it's a traditional employee-employer. So they're talking about who is exercising control over this person in their day-to-day duties. That is the employer, that should be the petitioner. And then finally, there are some additional provisions that have to do with the USCIS being required to provide specific explanations for when they are choosing to shorten the amount of time that someone is granted on their H-1B visa. So as an employer, you're entitled to request a specific period for H-1B, and it can be, as little as 5-6 months, let's say, and as much as 3 years at a time. So if you request 3 years and USCIS decides to give you 1, then they will also provide an annotation explaining why you were given a shorter period. With respect to third-party work sites, the USCIS will automatically only issue 1 year for those situations, because they would like to review this petition and make sure that the relationship is an appropriate relationship. Finally, the regulations are going to broaden the USCIS's ability to do worksite inspections. And the failure of a contractor or an employer to actually cooperate with the worksite inspection could result in termination or revocation of an already approved H-1B, plus denial of a pending H-1B. Plus, there are going to be more restrictions on the need for an employer to demonstrate at the time of filing that they have a position available and they have the funds available to hire the H-1B worker. So it's not so much at the time that they will start, but from the moment of filing, everything has to be clear. So it's a very different landscape from what we have seen so far, and there will be more limited opportunities for individuals, even though they might be, with an employer on OPT and the employer really likes the work that you're doing and they want to help. It's not going to be as simple going forward to achieve those results. So it's very important, as you are looking at job opportunities, that you make sure that you're looking for those opportunities that truly match your qualifications, and that you are trying to make it as clean of a petition as possible on the end of the employer as well as on your end. So try to make sure that you're staying in status, you're looking for opportunities for employment that are actually associated with your field of study, that you're being paid the appropriate amount, and that the employer is bearing the cost that they should as the employer, to make sure that down the road you will not run into any issues with your petition actually being approved if selected for further processing. So as far as those two topics, this is all that I have to say. And I did see, and I'm sure Kiki, you did as well, that there were some questions coming in with respect to the election. And I think that it's safe to say that most of these things will be impacted by the election. According to the agenda for the Biden team, if we were to have a change in administration, the immigration reform will be a top priority, and there should be comprehensive immigration reform and an extension, or rather an increase, not an extension, excuse me, an increase of the available visas for family and employment-based categories, according to what they're saying the plan is. And lots of things like the public charge rule will likely go away. The proposed rule on F1s may go away because it is a proposed rule. It becomes more difficult to say exactly what will happen with rules that have become final, especially if they're 90 days prior to a change, or more than 90 days prior to a change in administration, because to be able to remove those rules, you have to go through the similar types of processes that had to be undertaken for the rules to be put into effect in the first place. And those processes are time consuming. Now, if there's a legislative fix, again, that is a better way to do it. Okay, so a
Thanks,
question
Elsa.
about, yes.
I think there's another question in the chat. Let me go
Go ahead
to.
if you want to grab it.
These are some of the questions that came in before. I think the other thing that I would add regarding the election is that, I think that, if there is a change in administration, as Ilka said, or these things take time, and they're not going to be immediate. And we're also doing this, keeping in mind that we're in the middle of a global pandemic, and the tighter that the economic constraints become on everybody, the tighter the constraints are going to be with regard to certain different immigration benefits, and what those priorities will be within the different application processes depending upon the immigration benefit that you're going for. So I think, as far as immigration attorneys are concerned, in the last weeks, this has been a frenzied time. We're getting hit left and right. I think it was the week before last. By Thursday, there were I think 5 or 6 announcements of kind of, major upcoming rule changes, et cetera. And so looking to the election, there's speculation that it's trying to get as much in as, quickly as possible. And undoing that, as Ilka said, it's not going to be something that's instantaneous. So preparing for these kind of tighter regulations going into next year, even if Biden were to win, I think it's smarter to get your ducks in a row. And also, and this is my personal opinion, that comprehensive immigration reform, I think, has need to happen for a long time. It will take Congress to be able to do that. But it, 180-degree change, just going in the opposite direction, I think will just, it will just inflame, we're just kind of inflaming one another. So hopefully there'll be some middle ground that we can get to. But like hanging one's hat on a Biden administration, especially in the short term, is, I don't think is prudent, just in the same way. We've seen a lot of changes in the last 4 years, but it took a couple of years to really get these things up and running and going and being put into effect. And so now, that's what we're seeing. We're at the end of, towards the end of a first term or possibly an administration, and that machine is oiled and it's pumping out a lot of work. Ilka, do we want to start these questions? I don't know. I think while I'm sharing my screen, it's hard for me to see the chat. I don't know if there's other questions.
There have been 2 or 3 questions that came in. A couple are related to the questions we received previously. So I think it makes sense to go through the questions we received ahead of time, provide those answers, and then we can open up the.
Okay. So the first question is, will applying for the diversity visa still be an option, and how does that affect current status in F1?
Okay, so I'll go ahead and take that one, I believe. So the diversity visa program is still available. The window for filing for DV 2022, actually at this time, has opened up, and you have basically until the end of this month to go ahead and get your entry in. And anyone who's in the United States and has maintained continuous non-immigrant status since their last entry can adjust based on the diversity visa once their visa number becomes available. And according to procedures of the USCIS in effect, you can file 90 days in advance of your visa number becoming available. So if some of you are keeping track of the visa bulletin, in the visa bulletin, if you look at the bottom after the employment-based chart, there's going to be specifically a chart for diversity visa cutoffs. And if you notice, those cutoff dates are announced 60 days in advance. So in each diversity visa, or pardon me, visa bulletin, you have diversity visa cutoffs for the upcoming month as well as the following month. And the visa bulletin itself is released a month in advance, more or less 3 weeks in advance, let's say, based on when in the month it is released. So if you look at the visa bulletin in September and you're looking at the October visa bulletin, you already will know the dates that apply in November and December. So with that in mind, you could file 90 days in advance, and you should, because you want to have the maximum amount of time available to you to process your adjustment of status through the diversity visa lottery. Because once you hit that end of the fiscal year, so September 30th of the year for which you were selected, you can no longer process, and it doesn't matter that you filed your application timely. And it also makes sense for the diversity visa lottery specifically to work with an attorney who does this sort of practice and knows the diversity visa lottery well, because you want to make sure that they're using the proper channels to communicate with USCIS, to get USCIS to treat your application on an expedited basis, so you actually receive your permanent residence before September 30th. And I can speak to several consulates throughout the world and the USCIS Chicago office that they do try their best to help diversity visa selectees process. So you have to be, if you're selected, proactive in how you're going forward with your case. And I definitely encourage you, if you're from a country that's eligible and you're maintaining status, file for the diversity visa lottery. It doesn't hurt, it could help.
I think we hadn't actually talked about saying anything about this, but you say speaking with an attorney or working with an attorney who specifically handles DV lottery cases. So is especially important. Immigration law is a section of law, but when I introduced myself, the reason that I was specific about the types of immigration law I practice is because we are, as attorneys, generally quite, we're specialized, and we, not an official specialization, but over the course of your experience, I do a lot of asylum. I do specifically a lot of Central Asian asylum right now. We get into, we just amass knowledge, and those are the things that the types of the law that we become very familiar with and kind of hone an expertise in. And larger firms are going to be able to handle all different types of cases. But if you go in and it's a small firm or it's a solo attorney, and you're really questioning, or you have some question as to whether, like, how many, do they handle diversity visa cases? Do they really handle asylum? Don't be shy on asking those things, because it's important that you have a well-seasoned attorney and that they be an attorney. Immigration law is plagued by notario fraud or notary fraud. In many countries around the world, a notary public is someone who is also an attorney. In the United States, a notary public is someone who has applied for, has to pass a minimal background check, and essentially witnesses signatures. They are not an attorney. And notary fraud in the form of offering immigration services is considered the unlawful practice of law. In Illinois, it's actually illegal. It is not aggressively policed, essentially due to the law enforcement capacity to police it, but it is a huge problem. And under an aggressive administration, such as the Trump administration with regard to immigration, I cannot tell you the heartbreak that we see on a regular basis from people who went in and had notaries that helped them with their immigration services, or filled out a form, or whatever have you, gave legal advice. And the result of that is either that they have violated their status unintentionally because they were being advised by someone who is not an attorney, and they now have a target on their back. This administration is heavy enforcement with regard to being placed in removal and deportation proceedings. So in deportation court, or in immigration court, in deportation proceedings, there's a much higher likelihood of being detained in immigration jail, even if you are, not a violent offender. And so being very careful on that, so if you go in and somebody tells you, oh, they have somebody, they're an immigration specialist, and they're quoting you a fee of, $500 for something an attorney would quote higher for, they're not signing the forms. They will not be found when it circles back on you. It does not matter what they told you or advised you to do. It is your signature that are on these forms, and they're under penalty of perjury. And that means, an immigration officer, even if they realize that you may have been the victim of notary fraud, they're not going to be able to do anything about it with regard to helping you out in an immigration process. That will come back to you. So there's a lot of work in Illinois and through the American Immigration Lawyers Association Chicago chapter, especially in the Chicago area, to address these issues. Our licensing board for attorneys, it does a lot of work to address these issues, but it is pervasive. And probably the most common place that you would get it is at a tax preparer's office, because advertising as an immigration specialist draws attention, but you don't have to be a certified public accountant to do taxes. And we see it all the time. I don't know, Ilka, I'm sure that you see a good amount of it. I spent 2.5 hours with a woman yesterday who is now in removal proceedings, and it's all because of, a notary saying, I handle immigration work, helped her out on a case, and it ended up landing her in court. And it all started from the understanding that a notary or a notario is an attorney, and that's just not the case in the United States. So I'll end my rant there. Next
Necessary
question.
rant.
Yeah.
So,
Can international students still apply for permanent residence based upon a petition from a lawful permanent resident parent? Yeah, the answer is yes. You're going to be subject to the Department of State visa bulletin as far as what your priority date is. So the date that your parent submitted that petition. For you, it's called an I-130 petition for alien relative. And you can adjust your status to a green card while being in the United States, as long as you maintain continuous lawful status in the United States until that visa number is available. So if you have a priority date of, what is today, October 14th, 2020, and as the law stands now, there's a 5-year wait for a visa number for your type of visa, in order to apply for your green card without having, to leave at the end of whatever your current status is when that visa expires, and assuming there's no change of status or extension of status, if you are remaining in the United States, you have to maintain that continuous status without violations to that status, meaning there's no argument on the part of the Immigration Service that, okay, well, yes, you're stamped in and admitted in this status, but you actually committed a violation, which, even though we're just coming upon that knowledge now, actually legally acts as a termination of that lawful status at that date. So it's maintaining that continuous status when the petition is from a lawful permanent resident parent or spouse. It is extremely important. Well, curricular practical training, or CPT, sorry, I left off the quote mark there, and optional practical training, or OPT, be available in 2021? Yes, to the best of our knowledge, it is. There haven't been any announcements that it will not be available. I don't know, Ilka, if you want to expand on that.
No, I mean, the only thing to be aware of is that employment opportunities might be more limited because of the state of the economy, but there have not been any specific changes to CPT or OPT, and DSOs who are kind enough to be on this panel with us, if there's anything that you would like to add or anything that you are aware of that we are not, please do enlighten us all. But my understanding is that there aren't any specific changes as of right now.
And then the next question is, are there any OPT regulations or options specific to Canadian nationals? Whoa, holy echo. So no, there haven't been any announcements specific for new OPT regulations or options that are specific to Canadian nationals. Ilka and I were actually researching this earlier today, making sure, because specific rules to say Canadian nationals or Mexican nationals or et cetera are treaty-based special regulations. There are lots of things changing, the end of NAFTA, et cetera, but there have not been any announcements of anything specific to OPT and Canadian nationals.
So then,
the next, go ahead.
No, it's fine. Go ahead and ask the question.
What are the requirements and process to apply for OPT after graduation? So post-completion OPT.
Okay, so again, with the caution, I always believe DSOs are the best source of information when it comes to OPT and these things. But so you must apply within 30 days of your I-20 being endorsed for OPT. The earliest that you could apply once your I-20 is endorsed is 90 days prior to your date of graduation. And you must file no later for EAD than 60 days after completion of your program. Once you receive the EAD, you do have 90 days to secure employment. If for some reason you are unable to secure employment, you are still able to take advantage of your 60-day grace period and also enroll in a different program to maintain F1 status. And again, just like we mentioned a couple of questions earlier, the key this year would be actually being able to secure employment more so than being able to apply for the OPT and get the work authorization. Just from a practical perspective, if you can file 90 days in advance of your graduation and you're intending to file, do file early, because USCIS takes sometimes longer than 90 days to process that work authorization, and you want to make sure you're taking full advantage of the time that you will be given and that you're securing employment timely.
Hey, Ilka, can I just make a quick comment? I'm Dawn. I'm actually the DSO, since you referenced me.
Please do.
I just wanted to add that no, there have been no changes at this time to OPT and CPT policies. Hopefully there won't be any coming, but if something comes up, we will certainly let you know. There are detailed instructions for those processes on the International Office website. And who are graduating this semester, we are in that 90-day period. So if you haven't started the OPT request process, I encourage you to do so as soon as possible. For students who are graduating in May, that's like around February.
Thank you, Dawn. And yes, when it comes to issues of OPT, the schools, your DSO, the schools are the ones that are controlling these issues. They're the ones who really are the experts in them. I do get calls from students who, there are issues in CVIS, or there may be issues with OPT, and it's really working with your DSO and going to them to understand if there is a way to rectify things or what the source of an issue is going to be key, because as immigration attorneys, we don't have access to these systems. And the DSOs are the ones who are really the experts in that field. The last question is, how does employment authorization work in the performing arts industry? Knowing that the theater industry is at a pause, how do we guarantee that we can still work post-graduation? Ilka, do you want to speak to that, or I can start off?
I can start. I don't mind. I think we're both on the same boat with this, that it's because it is an industry specific question. If you can find work, you would be able to work. For the performing arts, you have multiple types of employment-based visas that might be worth looking into, including if you are exceptional in your field or extraordinary in your field. There are specifically visas for extraordinary ability artists and entertainers. You also have some visas that are employment-based, that are for individuals coming to the United States to engage in a culturally unique performance. Those are more limited and traditionally require that you have a schedule and itinerary to participate, but there might be options that you can pursue that are not traditional. If you do not have one of those options available to you, but you have the ability to continue your education, I'd probably suggest holding off on doing your OPT after this degree completion and enrolling in a different course of study, so that you're able to take advantage of your OPT at a later time, maybe as pre-completion, when the theater industry is better functioning and we're not in the middle of a pandemic.
Speaking to how do we guarantee that we can still work post-graduation, unfortunately, there are no guarantees. And like, as I was saying, the overall economic health of the world, speaking to the United States and the economy in amidst a global pandemic, are going to have huge effects on the ability to get work. So my understanding of, post-completion OPT is that you can have a total of 90 days of unemployment, I think, in 12 months. If it's going to be outside of that, then, you're going to hit issues with it. But there is no way to guarantee, that you would have a position, or that position would be as long-term as anticipated, depending upon what goes on with COVID and with the economy. I am going to stop sharing my screen just so I can see chat if I need to, and it's just a bit easier this time.
I would also add, with the 90 days of unemployment issue, that immigration has really started enforcing that in the last couple of months. So there is no guarantee of employment, and if you can't find one in 90 days, my recommendation is that you make plans to leave the country so we can notify immigration before you exceed those 90 days of unemployment.
Thanks, Dawn. I'm just taking a look at the chat right now. There's a question that just says, how will this affect OPT? I'm not exactly sure specifically what that the question asker was speaking to. I believe that the recorded webinar is going to be on YouTube. And we spoke about Canadian specific issues. Ilka, can you see the chat?
Yeah, I can. I'm looking at it with you. So we have, so the next two questions after the one about whether Canadian, are there any differences because you do not process a visa? So in the sense that you will continue to be processed in the same way at the port of entry, you can because you are Canadian. But as far as what happens with your status here, those new regulations will equally impact Canadians. And then there's a question about, can someone with a diverse background apply for different roles at the same time? So I think the question might have to do with the specifically H-1B information that we were providing. And I guess if you have two different bachelor's degrees, right, and you are able to search for work with either of those degrees, or you have significant experience in one field and in a degree in another, that should be okay as long as you have at least the minimum required qualifications for the position that you are being offered, and that your qualifications are specific to that profession and occupation.
Thanks, Ilka.
Yep.
I don't know if you want to speak to the EB1 question.
So if you have earned a doctorate in the US, is that enough to file for EB1? Probably not by itself, but if you are also someone who is known in your field and you have published materials and you have notoriety internationally or nationally, you might be able to meet the EB1 criteria. This is not the sort of question that can be easily answered in the type of format that we have set up here, or even over a short presentation. If you have specific questions with respect to this issue, you can reach out to us. And I always say about this field that I can give enough information to be dangerous, but I certainly can refer you to someone who is a specialist in the area. And I believe also the university might have someone who does more employment-based things that they could refer you to, with specifically speaking to EB1, because it's one of those visas that you truly do need to be a specialist to undertake. And there's a need to provide extensive documentation. The good thing about EB1 though is that you can be self-sponsoring if you meet those criteria, so you don't necessarily need to have an employer or an offer of employment.
Thank you, Ilka.
Of course.
Um,
And I think those are all the, no, wait, there's more. I didn't scroll down. So again, the question about COVID and employment, that is COVID is a major reason why many people are not finding employment, right? So it's not any different. I have one specific case where someone had an H-1B position in which they were employed, and because of COVID related layoffs, they were laid off. But that individual had an exam that they wanted to take later in the year. So in that case, we were actually able to process a B2 extension because of their inability to travel as a result of COVID. And then because they had plans to engage in visitor appropriate activities, including attending that exam later in the year. And now the other thing to keep in mind is that if you are someone who is selected for the H-1B but then loses employment as a result of COVID, or you had a job offer, you're counted against the cap, you're approved, and then your employer revokes your H-1B job offer, being counted against the cap means that if you find another position that is in your field, you can have that new employer file a new petition for you. And because you were counted once against the cap, you do not have to wait for the lottery. You're not subject to the cap for the next 6 years because of how the rules work. So in that sense, if you had a job offer that you were unable to take because of COVID, you can continue to look for employment after you leave the country to avoid accruing any sort of consequences, unlawful consequences, once you're overseas, if you're able to find additional employment when the economy improves.
Okey-doke. Where do we find an attorney? Is there a resource we can find appropriate attorneys? I think a good resource would be to go to AILA.org or the American Immigration Lawyers Association. As general blanket advice, whether it be to a prospective client or a family member looking for immigration, counsel, is to work with a member of AILA. So AILA.org, you can look there. They do have an attorney, find an attorney link there. We're going to give you our contact information, whether it's a type of case that we would work on or we would be able to assist. We also are happy to refer you to someone that, maybe a better expert on your case. Like Ilka was just saying, a referral to someone who knows like an EB1 specialist, and it really concentrates a lot of their practice in a specific part of immigration law. Those would be two good starts, but always I would say work with an AILA member. And AILA members are always happy to tell you whether they belong to AILA or not, and if they work on different committees, etc. And most people would have it on their website if the practice does have a website, etc. That's a duplicate. Can someone apply for a change of status after the 90 days job securing period? Or I don't know what DP stands for. Is that employment immigration jargon? I don't know.
Let me just see. I just stepped away from the chat, I think. Hold on.
As to the last question that came in, we didn't include that because that's very case specific. So if that would, if you were seeking consultation with an attorney, that would be something, appropriate for outside of this venue. But that's a bit too case specific to use something like, a panel presentation to address it. But back to that change of status question, that's not my wheelhouse.
So for this particular one, after the 90-day job securing period, so you get that grace period, but my recommendation is always to try to do as much as you can, as early as you can, to protect your status. Now, if you're doing a change of status, well, a change of status to what, right? So if we're talking about a B2 visa, well, what's the reason you need additional time and you need this visitor visa, right? So you also have to, it's not just simply filing the change of status, it's having an appropriate status to change to, and having the documentation necessary to back up that application. Because filing an application that doesn't necessarily have, I wouldn't say merit, but where you are unable to provide supporting evidence for why you need this additional time in the United States could be more harmful in the long run than helpful, because it could negatively impact your future ability to return on a non-immigrant visa to the United States if and when you do leave the United States.
That's a really good point. Thank you, Ilka. I think that's all of the questions we have from the chat. Is I missing something? Yeah, I think we covered them all that we can address in this forum. So I'm gonna just share my screen again real quick, just so you can have our contact information. Oh, there we go. So there's our contact information that's up on the screen now. And if you have follow-up questions or are seeking a consultation, we will do our best to address those. If it is something that is, complex, then we would be looking at a full consultation. Then, we would let you know that. But, part of the reason that Ilka and I do these types of presentations are because we think that it is important, to offer an opportunity for students to be able to ask professionals, you know, that might not necessarily be easy to find, sometimes afford, or just, you know, there's lots of kind of different choices, lots of different advice coming at you. And one thing that I will say is that, you know, there's a lot of bad and just incorrect advice on these chat forums and online. You know, I would say don't rely on what someone has written in an online forum about a visa experience, or describe, you know, may describe something that sounds exactly like your situation. Don't just take those as fact and act upon them in any way. Definitely at least consult with an immigration attorney that's knowledgeable in that specific part of immigration law to know what is going to be required of you. And also, you know, what are the long-term effects? You know, sometimes you're thinking you may be looking long-term in the next few years. And like Ilka was just saying, you know, when she's examining something, like she may be looking to 10 years down the line. Is this going to affect you being able to get back in after, you know, life's gone on, there are families now, et cetera, et cetera. How is this going to play out in the future? For something that looks like right now would work in those next few years. Is this going to be something that hamstrings you down the line? And really only being an immigration attorney and being in this every day as a profession is, you know, when you're really looking at things in kind of the law, very long term of the law, especially with how long it can take to finish some of these processes. So thank you for having us. This has been fun. Wish it would be in person, but I am grateful that we have Zoom so we could do this. Nice to be
Thank you
back.
very much, everyone.
Yeah, and have a great evening.
Have a good evening. Thank you. Bye.
Yes,
Bye.
thank you.
Thank you, guys.
Thank you, everyone.
Thank you, Kiki and
Bye-bye.
Ilka. We appreciate
Thank
your
you.
time and
Thank
information
you.
that you've shared with everyone. Like I mentioned in the chat, I will be sending out the link to the recording to everyone who registered later on in the week. So definitely be on the lookout for that. So thanks again, everyone.
Have a wonderful night. Bye-bye.
Have a great night.
Bye-bye.
Thank you.
You too.